Chair, you have a live mic.
All right, we got two no sooner than 1 o'clock. So you want to start with 11B
We actually,
or 11D? I'll leave it up to you.
we are going
What are we
to
doing?
start with 11D, please.
Okay.
That is formerly 16A13 is a recommendation to approve the payment of $1,650 to the River Oaks Homeowners Association for 5 years of unpaid assessments for Lot 44, Block A of Palm River Estates, Unit Number 7, according to the plat thereof recorded in Plat Book 12, pages 28 through 30, Public Records of Collier County, Florida. This item was moved at Commissioner McDaniel's request, and Ms. Trinity Scott is here to answer questions as needed.
And what was the agenda item on the consent, please?
16A13.
Okay.
I'm here to answer any questions that you may have regarding the agenda item. We are recommending approval of a payment of $1,650 of homeowners association dues for a lot that is owned in the River Oaks subdivision. The lot is utilized for access to a weir location.
Okay. Will you give me a little bit of history as to what's in fact transpired and how we've come to be in somewhat of disagreement? I think there's some people that are interested in speaking on this item as well. So.
Sure, I have a brief presentation that I can go through if you'd like. So the background is the county purchased this lot in 2004 for the purpose of accessing the Palm River weir structure for ease of operation and maintenance. The lot is a single-family residential lot. We do not have any improvements on the lot at the location, but we will utilize it for, as I said, the access to the weir location. At the time when we purchased the property, I guess I should say, we were unaware that the property was encumbered by a property owners association, and in 2022, the county received a demand letter for payment of assessments back to 2004, inclusive of late fees and interest totaling $27,000, give or take. We reached out to the homeowners association because, as I advised, the staff was unaware that we were encumbered by an HOA. The HOA has a collection policy that's shown on their website. It was adopted in 2018 that dictates that delinquent accounts are noticed on a 15 and 30-day interval, none of which the county's received. In December 2022, the county received an intent to record a claim of lien against the property unless the amount was paid in full. And the amount was $27,776.53. This is a breakdown of the amount. The total principal is $4,100. Late fees, interest, and certified mail charges make up the remaining portion of $27,776. We've had multiple conversations with the homeowners association representatives trying to come up with an agreement for an amount. We have coordinated with our county attorney's office to determine the county's legal obligation to pay the past assessments, including late fees and interest. Based upon that guidance, it was determined that the county would be obligated to pay the previous 5 years of assessments, which is $330 per year, equaling $1,650. And we have discussed verbally with the homeowners association. They have refused to accept that amount. They did provide, we worked with the homeowners association representative. We did get a bill for our 2023 assessment, and we have paid that. So and I will tell you that I have this on my own personal calendar at the office, so it doesn't fall through the cracks, as well as multiple other people in our financial group, to where we stay up on this because we don't want to be in this situation in the future. A few weeks ago, we received via email a delinquent assessment notice requesting $10,000, but there wasn't an explanation for the change from the previous invoice. So this brings us to where we are here today, which is seeking a recommendation to authorize us to make a payment of $1,650 to the River Oaks Association for our past 5 years of unpaid assessments.
I think we have public comment, don't we, Mr. Miller?
Yes, sir. We have 2 registered public speakers on this item. You want them at this
Yeah,
time?
let's hear from him.
Terry Woyland will be followed by Jim Capwell.
Good afternoon. I'm representing as president of the River Oaks Homeowners Association. And the invoice that she just referenced was one that was set in error by the current property management company. But we still stand by what our original notification was to the county that's owed on the lot. And the reason we're in disagreement over the 5 years is your warranty deed states that you're in an HOA, which means it was stated from the time you bought the lot through today that you had an obligation to pay the HOA. And so to come back now and say that you're only responsible for 5 years when you were negligent for all of the other years is unacceptable to us as an association. That's how we pay our bills. It's how we maintain our community. And if you're going to be a part of the community, you need to be a part of the solution, not a part of the problem. And Jim Capwell is on our finance committee and has also spearheaded this project and has done a lot of work on it regarding it and some of the other deficiencies as it relates to the water and lot association, or the lot within the association. So I'm going to let him speak on the balance of that.
Thank you. On behalf of River Oaks Homeowners Association, I thank you for allowing us to speak up on this financial dispute. The county is in no different position as any other lot owner. We are all governed by the same covenants, restrictions, and dues assessments, and I believe we all should be treated equally. In 2017, I was in a similar situation. When I moved in, I didn't know about dues. They told me it was a volunteer. $330 I should have paid. I was 6 months late, and I got $1,800 I had to pay, and that's just the way it works. As Terry pointed out, on your warranty deed, and I filed one with the court reporter here, the property was purchased not in 04 and 03, May 6th, and it clearly states in your warranty deed that this property is subject to all easements, restrictions, and reservations of record. If we go to the Declaration of Covenants, the developer declares that any lot in River Oaks subdivision are subject to the following easements: restrictions, covenants, and restriction. Is this not an option? These restrictions run with the land, and the benefit and burden of them shall be binding on all parties, including all successors and assigns. Article 2 of our Declaration of Covenants says, no building or structure shall be constructed, erected, altered, placed, or permitted to remain on any lot other than one detached single-family dwelling. Article 15, each owner of a lot in Palm River, automatically of recording of a deed, conveying title to such owner, becomes a member of River Oaks Homeowners Association, subject to all powers, duties, dues, liens, and assessments. Okay. In the event of a violation of any of these restrictive covenants, the association shall have the right to proceed at law or in equity to complete compliance with the terms hereof or to prevent the violation of breach of any of them. The failure to enforce any rights, reservations, restrictions, conditions, or limitations herein contained, however long contained, shall not be deemed a waiver of the right to do so thereafter. Any delinquent owner agrees to pay a reasonable attorney's fee for the enforcement of these use restrictions. If we go to Florida statutes, okay, all parcel owners by definition are members, okay? All members under Chapter 720.303 have the right to attend all meetings of the board. Under 720.303C1, notices of all board meetings must be posted in a conspicuous place in the community at least 48 hours in advance of a meeting.
Keep going, sir.
Okay. Under 720, 3085, number 3, assessments and installments on assessments that are not paid when due bear interest from the due date until paid at the rate provided in the declaration of covenants or by the bylaws of the association, which rate may not exceed the rate allowed by law. If no rate is provided in the declaration or bylaws, interest accrues at 18%. Any payment received by an association and accepted shall be applied first to any interest accrued, then to any administrative late fee, then to any costs and reasonable attorney's fees incurred in collection, and then to the delinquent assessment. Those documents are the same ones that I have to abide by and the county should abide by. Now, I understand much more intelligent attorneys than me will have taken this up. They want to drop on us statute of limitations in only 5 years. I believe it will be forced or enforced in a court of law that you have a warranty deed that states that you're required to pay these assessments. You've had proper notice. You've had the ability to attend board meetings. Now, in all fairness, no one's driving through the community. I understand that. But as a homeowners association, we complied with Florida statutes. Okay, the minute we found out that there was a delinquency, which I believe would have been in like late July of 22, we started corresponding with the county to ask how do we handle this and so forth. We have had to foreclose on members. We've had to sue members for collection based on these same rules. So I believe if you go back to Collier or River Oaks versus Brunt, they raised the issue of statute of limitations, and the judge summarily dismissed it, stating you had notice on your warranty deed when you bought the property, you needed to follow those rules. My only question to the attorneys would be, what rule is there, what code provision that says the county is not subject to our covenants, our bylaws, our articles of incorporation? Because technically, I think we're in good standing on this. And I'm even questioning why they haven't even approved the weir structure on that property when our covenants clearly state owning a single-family home. Now, we're not here to raise that issue, but we do feel that we're owed this money and we should receive it. Now, back in January of this year, I sat down with Amy Patterson and Trinity Scott, and we came up with a compromise that I thought was going to be binding until the lawyer came back and said no. So we're here to appeal to you as fellow citizens, as our government leaders, and as businessmen. We're asking you to do the right thing.
Okay, let me go to Commissioner Saunders, sir.
Thank you. I've got a couple questions for our staff, and I may have a question for you too, but I got a question for Ms. Scott and a question or two for Mr. Klatzkow. This piece of property, we're only using it for access to the weir.
Correct.
Do we still need it for
Yes.
access to the weir? And so I guess we're in violation of their rules because we don't have a house on there? Is that?
We have nothing on the property at this moment.
But we still need the property.
We need the property for access.
Okay. Then, and Mr. Klatzkow, in terms of the statute of limitations and all of those issues, I'm not really persuaded that that should be something that we should try to live or die on a technicality. I think we need to play by the same rules as everybody else in their association. I'm sort of disappointed that we still need the property because that would sort of get us out of this association. But I think we should, if we did not make the payments and they have specific rules dealing with interest and late charges, then I don't see why we should try to avoid paying those full amounts. I guess another question is, I assume we're doing, I don't know if we're doing any work in the neighborhood or anything that would offset any of those costs. I'm assuming that that's not the case. So my view would be let's pay the whole thing. I mean, it's a tough pill to swallow, but we shouldn't be trying to live by different rules than we expect other people to live by.
Commissioner McDaniel.
Yeah, well, there was some discussion on that note. with regard to in-kind work that we had done that was theoretically the responsibility of the homeowners association. Do you know what that number was?
Yes, it's actually in the executive summary. We completed in December of last year, this is actually before and after picture of a stormwater outfall, where road maintenance, under the prior road maintenance director's direction, our road maintenance staff went in and cleaned out this area and did install some riprap along the privately maintained stormwater outfall. And the total labor, equipment usage, and material based on our production report was $9,049.42.
I have a question for you, gentlemen. So how many HOA members are there?
169 thought until we did our research and found out the county's 170, so we have
Okay.
170.
So every 12 months, do those 169 people get a bill for their HOA fee? Or they just have to remember on their own?
Typically, they do, and we are going to make sure that we have everyone's email going forward. But there's nothing in the statute that requires us on an annual assessment to invoice. There is on a special assessment.
No, but, and I get that. But my question was, did 169 people every 12 months get a bill or somewhere in that? I realize number 170 didn't, or we wouldn't be here. But did the vast majority of people who you had a correct email address for? And I mean, I'm sitting here going, our email address would be the easiest one to get in the universe compared to the 169 strangers. So I mean, I'm sitting here trying to figure out where the responsibility is. I mean, I don't disagree with Commissioner Saunders, but did the majority of 169 every 12 months get a bill?
I can't support what the property management companies have done in the past. I can't support what the boards have done in the past. I can only tell you that we've made sure everybody's gotten some kind of a written notice or a knock on the door in past
So,
years.
and you recently then took, is that what I'm inferring
Yes.
here? Okay. When was that you took over?
Last week.
Okay.
I'll tell you it was July, because that's when we discovered lot number 170.
So did you discover in the other 169 that there were plenty of people that were past due that didn't pay for a long period of time, or it was just us?
It was just you. Everybody else we had to file suit against in the past and so forth. And it should be noted, some of them went back a lot longer than just a 5-year statute that the county attorney is proposing.
Okay.
We've got lawsuits in Brunt, that's 8 years.
So what would be the total, just for the record? What would it be if we?
The current demand was just delivered today for the corrected. It's about, I gave it to the clerk, the court reporter. It's like $29,950.
Hey, Ms. Patterson, I guess the next question I have for you is, if you were in conversations with them, what can you tell us?
So we did, as the gentleman said, we did sit down with him due to the value of this lot to stormwater, as well as the fact that he had presented that same information of other cases where they had treated other property owners the same way as us. Went back in time, attempted to assess them, actually took them to court. I can only speak for myself, but Ms. Scott was there too. We felt that the value of this lot far outweighed the risk of proceeding to try to litigate this. But I'm not the attorney, hence the reason why we had to confer with the county attorney. There's legal matters at hand here. Our primary concern was, number one, of course, being fair. We're not asking for special treatment, not saying we're special because we're the county, but secondly was protecting our asset.
Okay. Let me go to Commissioner McDaniel, and then I want to hear from Mr. Klatskow. Go ahead.
Well, and I wanted to ask, did I hear you say you have litigated and/or brought charges against other properties in homeowners association?
Yes, I have brought a copy of one.
Okay, so that is in fact the case, and I'm just going to say out loud, I agree with Commissioner Saunders in part. I think that maybe we ought to. We need to stand responsible for our obligations. The county needs to do that, and there certainly is a limited amount of responsibility for the billing purposes, arguably one way or the other, but I don't want to be in a position where a homeowners association has to litigate with the county because we're the owner of a piece of property in their subdivision. I don't find that to be acceptable. Even though there may be legal precedent, our county attorney may say something different with regard to what our actual exposure is. I don't want to litigate with a homeowners association inside of our community. I would rather reach a settlement, come to an agreement of some sort, and then go on, so.
Mr. Klatzkow, what can you add? And then I'll go to Commissioner Hall. I mean, if you want to add something, I know, just,
You know, there are legal obligations in there, I'll call moral obligations. If you feel like you have a moral obligation to pay, that's fine.
okay. Commissioner Hall.
I look past the moral obligation. I would want to be treated, I want to treat others like I would like to be treated. To not even be aware of this, oh, it's in your deed. How many times have you ever read your deed and looked at the fine print and realized that you had an obligation? You don't. You know you have an obligation when someone sends you a bill, hey, you're part of the HOA, and when that happened, we paid it immediately. So because we've gone for 20 years or however long it was, and we've got these $27,000, $29,000 worth of charges now, that's not how I would want to be treated. It's not how you would want to be treated. You were lucky enough to be aware of it the first year. Sir, you owe $330. Oh, okay. Now you're late, cost me $1,800. That's the first year. You know, you have a home on that property, a house that you live in. We don't. We access it to provide floodplain maintenance for the county in that area. So, you know, as far as a moral obligation, I'm willing to pay the $4,100 worth of principal that we owe and let the interest, let the late fees and all the hogwash, all of the greediness or all of the grab go, because it's just what's right. We're aware of it now. We were sent a bill, we paid it. We're always going to pay the bills. The clerk does an amazing job. So I feel like it's a greed thing against the taxpayers to try to grab this money because you think you can. And you can. I would just be a proponent of the moral obligation. We'll pay you the $4,100, the principal amount that we owe. You take it, let it go. We'll all live happily ever after. We'll access the weir, maintain the floodplain. You send us a bill, or we'll pay it every year, because Trinity's even got it in her own personal email. So that's where I'm at on this thing. I personally think the $1,650 should suffice for the statute of limitations, but on the moral side of it, I think we need to do what we need to do, and I'm willing to do the $4,100.
Commissioner Cole.
Thank you, Chairman. If I was hard lining it, I'd be aligning myself with Commissioner Hall right now, but I do feel in some way with the other commissioners here that, you know, we do have an obligation as a property owner and to the association, just like any other person would be in there. But also, I'd like to draw attention to the fact that we did use public money to maintain something or fix something that was your responsibility, and we didn't charge you for it. And, you know, that comes to about $9,000. So if we do come to a conclusion today, I think that possibly could be a possible negotiation point to where we get that we already used public money on something that, you know, it was your responsibility to use the money that you've already gotten from everybody else over the past 20 years. So I would be more comfortable maybe moving forward with something of that nature.
Let me hear from the commissioners, and you'll get a chance to say, Commissioner McDaniel and then Commissioner Saunders.
Well, that's exactly what I was going to propose. The plus minus is $29,000. You have $27,000 here. There must be another bill or something out there.
So in what Mr. Capwell is speaking of, this was interest based, this is the latest bill that we have received in our office. This is interest through December 31st of 2022. I'm sure that Mr. Capwell's probably recalculates that interest through perhaps today or some other date. So that's probably the difference.
So the round numbers that I had in my mind is 20,000.
Yep. 29 minus 9.
Correct, is the And that alleviates the association of the taxpayer expended funds for the drainage, for the drainage. I'm sorry, Terry was looking at me crooked. That alleviates the taxpayers for the money that we've already expended for something that was technically the homeowners association's responsibility, and picks up a majority of the deficits that are out there for the outstanding interest and penalties.
Commissioner Saunders.
Thank you. I agree wholeheartedly with Commissioner Hall in terms of how we'd like to be treated. I agree with you that this seems to be a little bit greedy, but I'm trying to look at it from their perspective as well. If they start making exceptions to how they enforce their rules, then those exceptions become the rule. And so, you know, I obviously I represent the county and the county taxpayers, but at the same time, I kind of see where you're maybe coming from in terms of, you know, you start making exceptions to any property owner as to how much the fines are and that sort of thing. Other property owners may very well try to raise that as you know, you've let one property owner off, you have to let all of us off. So that's why I was saying I don't think we should attempt to be treated specially. Now, the work that was done, if this is work that we would do in other neighborhoods at no charge, then that's one thing. If it's not, if this was something special, then that should be an offset. I agree with you, Commissioner McDaniel and Commissioner Colwell, assuming that this is not ordinary stuff that we do anyway. If it's not, then that's a whole different situation, and we should get a credit for that.
Commissioner Saunders, for this specific area, it is the maintenance responsibility of the homeowners association. Our prior director at road maintenance, and we're working through some other issues that are county responsibility within the neighborhood, and Mr. Capel and I have had lots of great conversations and are continuing to work through those items. But in this particular instance, it was the homeowners association's maintenance responsibility, but it was so bad that our prior director did send our staff in for a few days to get the work done.
When did we do that work?
In December of 2022.
Did we bill them immediately?
We did not.
I know he's trying to say something, so maybe he agrees.
Let me just get to Commissioner Hall, and then you'll have heard from all of us, and then you can summarize. No one's getting stifled here. Don't worry. Commissioner Hall.
So when it comes to dual responsibility, you know, we wouldn't be, I don't think we would be being treated special, because the HOA has a responsibility or a burden on them as well about just dropping this on us after all of this time with penalties and with interest. So I don't think that anybody that was if 169 others are getting a bill every month or every year, and they're understanding that they're under that obligation, nobody's going to be treated different because it's the exception and not the rule. I just, standing on what's right because it's right, I wouldn't want to be treated that way. That's why it sticks in my craw. And however we vote, we vote.
The question I have, and then I'm going to turn it over to you. So the other people who were delinquent, and like you said, you either took them to court or they caught up or all or both. The ones that caught up, did they pay interest willingly, or they just caught up on the actual charge?
There's never been a forgiveness of debt because of the legal ramifications. What you do for one, you must do for all. And can I carry on?
Yes, so you charge them the same
Yes.
same percentage of interest?
According to Florida statute, 18% interest, $25 a year late fee.
Okay. Yeah, floor is yours. I have nobody lit up here, so hearing all the comments here.
Back in January, around January 15th, I had a very welcoming meeting with Amy Patterson and Trinity. And from that meeting, I thought they were very fair. We put everything out on the table. We came to a decision, $20,000 cash plus about 4 non-cash things. It was I who asked for the 4 non-cash things. Even though some of those were not our responsibility, I wanted it to be an all-encompassing agreement so I can use that to go back to the other homeowners who are saying they don't get a break. I didn't get a break. So that's really was presentation-wise. As you want to argue about the 9,000 in kind, I offered to jump in there with a chainsaw and clean it. Jerry Kurtz said, no, this is not your responsibility. You only control the lakes, you control the weir, but this is the overflow in the river, and he says you're not allowed to touch anything in the river. That's county responsibility. So whether we're being charged for it against us or not, it's going back to the original agreement I had with Amy Patterson and Trinity of 20,000. We know we made some mistakes. We feel you guys made some mistakes. We want to work together with you. I would accept, because I already have the board president behind me, and he's got the authorization to accept the 20,000 and move forward.
Commissioner McDaniel.
I'm going to make a motion then that we offer 20,000 as a settlement for this dispute.
Second. All in favor?
Aye.
Opposed?
Aye.
Passes 4-1.
Thank you.
Okay. Don't forget to bill us.
More importantly, don't forget to pay every year, even if you don't get a bill.
Right.
It's on my calendar, sir.
What's next?
Item 11B is a recommendation to accept the after-action report for the 2023 Florida legislative session and provide guidance as preliminary planning begins for the next legislative session. Mr. John Mullins, your Director of Communications and Government Affairs, and the rest of his title, will present.
For the record, John Mullins, your Director of Communications, Government, and Public Affairs. Happy to be here. Joined today, as always, at the end of the legislative session by Lisa Hurley, who covers more ground for this county than probably any lobbyist does for any county in the state of Florida, and I am not joking in that regard. She does a lot of work for this county, and she is greatly appreciated. She'll be coming up to talk to you in just a few minutes to have a substantive conversation, to talk about a little bit of inside baseball, right after I get through the monotonous slideshow presentation, which I will get through just as quickly as Terry will allow me.
I don't think she's a lobbyist. We like to say what? Action, what do we say? Action-oriented official or something, right? Lobbyist has got a bad.
Starting off with some quick statistics. There were about 1,800 bills proposed this year during the 2023 legislative cycle, which was down quite a bit from last year. But there were a lot more amendments to those bills this time as opposed to last year. The number of bills passed increased by about 70 bills over last year. And the governor now has 15 days, because the legislature has adjourned to sine die, to act on any bill that's before him, sign, veto, or allow to become law without signature. And this time there were 443 bills on the county track list, which is down a little bit this year, and that is greatly appreciated. It was overall a more kind and gentler session as it pertains to county government, and that's what the president promised us, and I think she's delivered. Now we'll start off with some fiscal features of the regular session, and keep in mind the governor still has line item veto authority, so some of this could change. Starting off with the overall budget, caps out at about $117 billion this year. The days of double-digit billion-dollar budgets are over, and as Florida continues to grow, so does the need to facilitate it. Starting off with some hurricane relief, the Division of Emergency Management's new program for Ian and Nicole recovery received $350 million, and this is a new program to help mitigate local government revenue losses and operating deficits, to make infrastructure repairs and conduct beach nourishment, and to complete debris removal. The only catch is you have to certify that you have insufficient federal, state, and insurance funds in order to qualify for that money. And if for some reason you get some of those funds later, you have to return what you received from this particular program. Beach renourishment also received $106 million, and this is a program that would provide 50% for beach renourishment projects and 75% match on inlet projects. The last item down there, the Emergency Preparedness and Response Fund, is receiving $1.4 billion, and this is the governor's fund that he has in responding to or mitigating emergency situations during a declared disaster. The governor's job growth program also received $75 million this year, and he controls that in its entirety. Visit Florida, which is usually in jeopardy of being extinct at the end of every legislative session with the governor's backing, survived yet again and received $80 million for this next year. And the BEAD program, which is the Broadband Equity Access and Deployment Program. It's a federal program for broadband deployment, mapping, and equity, and it's administered through DEO. They're getting $112 million this year, and housing and community development projects are getting $118, and she's already giving me the death stare. Moving into housing, and we'll start with the Sadowski Trust, which is funded at a pretty high level. They receive funding from the documentary stamp tax proceeds. The state apartment incentive loan received $259 million this year, and we're going to talk about that a little bit more here shortly, as they're going to get a little bit more of a supplement to that. Also, the Florida Hometown Hero Housing Program received $100 million as well, but they also got another plus up that we'll discuss here shortly. Moving to the environment, the Everglades got about $500 million in the budget this year, and water quality improvements, including water projects, of which we are a beneficiary, and we'll get to that when we get to our project requests here in a little bit. There are also more funds for trying to combat the blue-green algae epidemic that we've been having, particularly up to the north, with more money going towards the task force and innovative technologies to try to combat the algal blooms. Moving over to transportation, the work program is about $13.6 billion this year, and of note to those programs typically funded, the local transportation initiatives road fund projects. We are also a beneficiary this year, and we will get to those shortly. And the transportation disadvantage program also received $8 million. But the big ticket item was the governor's Moving Florida Forward initiative that was announced in Fort Myers back in January, and Commissioner Kowal and I were on hand for that announcement. And this program has 4 projects of benefit to Collier County. There's the I-75 Pine Ridge Road widening and diverging diamond construction, I-75 additional lanes from Golden Gate Parkway to Corkscrew Road, and on behalf of all commuters, that can't happen soon enough. And 2 projects along Route 29, including the 4-lane divided highway loop around downtown Immokalee. Now, the governor was looking for $4 billion to leverage in generating an additional $3 billion over 4 years. And what the legislature did was they opted to provide him $2.5 billion via a budget amendment from the Joint Legislative Budget Commission, and that'll be occurring shortly. And then later on this year, as the plans progress, they can go back before the Budget Commission to get the additional $1.5 billion. The tax package is always very popular with constituents, and this year some of these things have grown. There is now a 2-week back-to-school sales tax holiday that will occur twice in the next fiscal year, in July and again next January, as will the disaster preparedness holiday in late May and again in August. Freedom Week is now Freedom Summer from May to September, and last year's Tool Time holiday continues without change this year. The energy-efficient appliances will also enjoy a tax holiday for 1 year, including the now very popular gas stoves. There's some permanent tax relief on things like baby and toddler items, also adult diapers and incontinence products for people like me, and oral hygiene products will also get a permanent sales tax break. Agricultural fencing to keep your cows where they're supposed to be. You can get a tax break for that. And transportation and production equipment for natural gas will also get a permanent sales tax break. Firearm devices such as gun safes and trigger locks will also qualify. Now moving on to our project requests for this year. And once again, the governor still has line item veto authority, so this could potentially change. Though keep in mind, all of these projects are in President Pasadomo's district, and vetoing them would probably not be a very good look. Starting with Golden Gate City, $2.8 million has been obtained to match money already in hand, specifically for the design and construction of 15 outfall pipes and associated structures to reduce flooding in the Golden Gate City area. Palm River, specifically Area 4 that's shown in the purple area and abutting the Cocohatchee River, is going to get $3 million to also match money in hand to do septic and sewer conversion for 24 residential properties, along with the replacement of outdated water mains and other improvements. 2 one-mile sections of Oil Well Road will see lane and shoulder improvements and drainage improvements with the over $2 million secured for both items, along with the local match that pertains to them. The 4-point roundabout will realign Camp Kias Road and install a roundabout where it intersects with Immokalee Road and South First Street to provide a safer and more efficient traffic flow, with the $1 million also received from the legislature. 50 athletic courts under the Parks and Recreation Division will get resurfaced through $450,000 being provided to match the $350,000 already on hand. And this will take everything from design all the way through final inspection. And why not? Let's buy a boat. But in this case, it's not a pleasure boat, it's a work boat. We're going to get $110,000 this year for a Weedo Truxor workboat that will allow for the mechanical harvesting of vegetation in some of our waterways in lieu of chemical spraying. And as you may recall, last year, Representative Mello had legislation that was trying to advance this process a little bit more, and she was instrumental in helping us get this across the finish line.
John, who owns that boat once we get it?
You do, sir.
No, but I mean, what department does it fall under?
This will be under stormwater.
Okay.
Trinity. All right, and also, this is not new money this year. This is money from last year. The Golden Gate Senior Center expansion. Because of Hurricane Ian and some issues getting architects and contractors online after Ian, we weren't able to make the timelines in securing those services for this actual project. So Lisa was diligent enough to get this added back to the budget as a revert and reappropriate. And with Senator Passidomo's help, we now have another year to spend that $250,000 for this process. And last but not least, in the funding requests, the $500,000 as promised by the Florida Department of Veterans Affairs is included in the back of the bill, and we will have the money now necessary to do the preliminary design and engineering for the facility. And of course, it goes without saying that we want to thank President Passidomo, and we want to thank our representatives in the House, Adam Botana, Lauren Mello, and Bob Rommel. All together made for a pretty powerful team this year and got a lot accomplished for Collier County, and it is greatly appreciated. Of course, I would be remiss if I didn't mention at the federal level that we also have $3.6 million currently earmarked in the Transportation, Housing, and Urban Development Appropriations Bill. And though this has a ways to go because markups don't start on this bill until probably another couple weeks and will go for about a month, we're hoping that with the stewardship of Representative Mario Diaz-Balart and our crew at Becker Law, we'll be able to keep this protected in the appropriations bill through final passage, hopefully in time for the October 1 start of the federal fiscal year. All right, on to general legislation of interest for the 2023 regular session, and many of these bills are awaiting the governor, though he is signing bills at a pretty quick clip already this year, as if he has somewhere else he needs to be. First, we'll start with See You Next Year. These are bills that had the interest of one or more members of the board, and we'll start with a few that didn't make it across the finish line. Starting with sovereign immunity, there's always strong interest in that bill. And while there's still a strong bipartisan desire to raise the caps and lower the number of claims bills that go before the legislature, this bill ran out of gas early on in the session, not really because of the merits of the bill, but because the sponsor was in the doghouse with House leadership over an unrelated matter. But we're sure it'll be back next year, probably for its 4th or 5th appearance in a row. County commissioner term limits were of some interest. Initially, the House had a bill that addressed term limits for district school board members only. That bill passed the House and went to the Senate. The Senate companion bill had that and also included 8-year term limits for Board of County Commissioner members. The Senate opted to, when both bills ended up in the same Rules Committee, to take up the House version instead and pass it. So now this only applies to school board members and does not apply to this board. And of course, I really thought that this bill was going to make it this time. It made it up literally till the last morning of session. Vacation rentals didn't get across the finish line, particularly after the House at the last minute made amendments that changed some of the local responsible party information that was in the bill, which really mirrors what we already have here in Collier County. And rightfully, the Senate decided not to agree with that position and let the bill die. But it'll be back again next year. All right, Ian response. This is some notable legislation that was a product of the Select Committee on Resiliency that was created by the President to address Hurricanes Ian and Nicole. And I think it was right before session started, both Jamie French and Chris Mason testified before this committee on Collier's experience during Ian, and we greatly appreciate them going to share their expertise in Tallahassee. Now, first, it requires the Department of Emergency Management to provide a model debris removal contract for counties that have a hard time coming up with their own. It allows residents to place temporary living quarters on their property for up to 3 years after an event. And it encourages the creation of specialized building inspection teams. It calls for expedited permits, retroactive to last September. It provides for building permit extensions following a declared emergency. And it prohibits raising building fees for counties like us until October of next year. The bill also provides that if you're in a 100-mile radius of Ian or Nicole landfall, you cannot adopt a moratorium on construction or redevelopment of any property damaged by Ian or Nicole before October of next year, and you cannot adopt more restrictive or burdensome amendments to a comp plan or land development regulations or procedures involving review, approval, or issuance of a site plan, development plan, or development order until October of next year. All these are retroactive back to September of last year. And lastly, you have 45 days to get your boat squared away after an event takes place and leaves it trashed. And we'll keep that in mind with our Weedo boat. All right, moving on to housing. And this was also a key component of President Pasadomo's package this year. The Live Local Act adds $1.5 billion to SAIL over the next 10 years to be directed towards mixed-use, urban infill, or developments near military installation. It also adds an additional $100 million to Hometown Heroes and expands the eligibility to all of Florida's hometown workforce. It encourages business donations toward housing for low-income residents by raising the tax credits by over $10 million this time. It also creates a corporate tax donation program to benefit SAIL. It provides a $5,000 per unit sales tax refund on building materials for developments financed through the FHFC. And it provides gap financing through a competitive application process for current construction projects experiencing an economic pinch. The bill provides a property tax exemption for developments that set aside at least 70 units as affordable housing for the moderate and low-income brackets. And this is a 100% or 75% exemption, depending upon the area median income unit being proposed. And rent of these units has to be at least 10% below market rate. The bill also provides the county the option of offering a property tax exemption for owners who provide units at the very low or extremely low income levels. And it applies a similar 100%, 75% exemption methodology based on the number of units dedicated toward affordable housing. The bill promotes affordable housing development in commercial, industrial, and mixed-use areas where at least 40% of the units are reserved for households earning up to 120% AMI for at least 30 years. And this may not require a zoning change. And okay, I promise I'm bringing this bill in for a landing. The bill forbids rent control in its entirety. It will require us to publish online our inventory of county-owned property that may be suitable for affordable housing development, and it requires us to maintain a public written policy for expediting permits and development orders for affordable housing. And yes, the 1-mile radius height provisions that we discussed earlier in the session still remain in the bill. All right, we're nearing the end here, I promise. I'm covering this bill simply because it's supposed to end all future preemptions. Okay, no one's laughing. No. Believe it when you see it. But under Senate Bill 170, the county can be sued for what someone may feel is an arbitrary or unreasonable ordinance. Now, you can avoid the suit if you withdraw the proposed ordinance or repeal it within 30 days of written notice. Also, before enacting a proposed ordinance, you must publicly post a business impact estimate, and you can produce that in-house. You don't have to hire an outside accountant or financial planner to help you with that. Now, before anybody panics, there are a host of exemptions, including compliance with state and federal law, ordinances that deal with the issuance or refinancing of debt, budget and budget amendment adoption, implementing a contractor agreement including grants, emergency ordinances, procurement ordinances, and nearly everything that GMD currently does. However, should you adopt an ordinance that does not qualify under these exemptions, and should the challenger meet the 3 criteria listed on this slide, the county would have to suspend enforcement, and in that circumstance, the bill creates a rocket docket to get us to the front of the line in court. All right, the pain's about to end. Just 2 more quick bills. Senate Bill 540 now provides that the prevailing party can recover attorney's fees and costs in comp plan and plan amendment challenges. So it's not just the plaintiff anymore. And House Bill 1383 does a few things, but the primary thing it does is it extends the expiration date of specialty contractor licenses at the local level for 1 more year. And of course, these and many, many more exciting bills will be in the Bills of Potential Impact report that will be produced here in the next couple weeks and provided to your offices and the department heads probably by June 1st. And of course, it goes without saying, we want to thank Lisa Hurley, our lead in Tallahassee, and her team at Smith, Bryan, and Myers. We want to thank our federal team at Becker and Polyakov, Amanda Wood, and Omar Franco. And of course, our internal staff, Ian, Diane, Josh, and Lee, who helped facilitate the quick flow of information to our frontline staff and then back to me to our lobbying team. And with that, I'm going to bring up Lisa Hurley to give you a good conversation and some inside baseball. And then after that, we will attempt to take on any questions you may have.
Thanks, Sean. Well, good afternoon. Lisa Hurley from Smith, Bryan, and Myers. Let me just first start by saying congratulations on your centennial celebration. I don't know if you're aware or not, but when you came up to Tallahassee this session, John Mullins brought a huge bag of centennial pins that Senator Pasadomo's office handed out throughout the entire session. So I think we've pinned half the state of Florida. So I heard everything went well yesterday. But thank you, commissioners, for coming up to Tallahassee. I want to start by saying that because it really does make a difference when you come to Tallahassee and you meet with all the stakeholders, from the officials at DVA down to our budget chairs that were responsible for providing us funding for your appropriation projects requests. They do like to hear from you, so thank you for taking the time to come up to Tallahassee. Also want to say thank you again to Jamie and to Chris for coming up because they provided some very valuable testimony in the both hurricane select committees in the House and Senate. In some of their suggestions absolutely made it into the bill. So thank you so much. So, you know, this session was, it was a really odd one. I'll tell you, we got off to a very slow start. In my opinion, you know, as you know, everyone came in the legislature, everyone was up for re-election, so we had a new president, we have a new speaker, so there were committee assignments to put out. I think both presiding officers gave their electeds more autonomy on what bills to file this session. So at least over in the House, when there's a limit on how many bills a representative can sponsor, that led to a little bit more analysis on deciding, you know, what bills we're going to put out there. So we kind of got off on a slow start there. The first part of session was definitely devoted for passing a lot of the governor's priority items. To John's comment earlier, as of today, I think he's signed upwards of 25, 26 bills already for this session. When a bill is actually sent over to the governor, that's a coordinated response between the presiding officers and the governor's office. But having said that, although there were fewer bills filed this session, there were more bills passed this session than the previous few years. So He still has about 330 bills that needs to be sent to him. And of course, one of those is the budget. So the budget landed at just under $117 billion. Little more than, almost $3 billion more than what the governor's recommended, budget recommendations were. And, the governor's recommendations don't have to be a balanced budget, unlike, the legislature. So the governor has not been shy historically on vetoes. Last year, he vetoed over $3 billion with a B from the budget. So I expect that there will be a sizable veto list this year. So on that note, although sitting here today, we're 9 of 9 on our appropriation project requests, we are working right now diligently to protect those from the veto. Your staff's working really hard. The governor's office on some projects is proactively reaching out to me and to local governments directly, asking for backup information on some of the projects. We did have that request on Friday, and your staff turned it around and got everything that the governor's office requested yesterday afternoon, so thank you for that. But my job is going back up to Tallahassee this week is continue meeting with the governor's office, his staff, to make sure they have everything that they need to make the final decisions on our projects. So I have to say that this was probably the most collaborative, coordinated session that I have ever witnessed. Again, it started off kind of slow, but when we started session after we got past our committee weeks, the bills started moving very fast. I think President Passidomo got most every single one of her priority items passed, and on the other side of the chamber, so did Speaker Renner. You're always waiting in session where, that big issue is going to pop and things, run off rails. And that didn't happen this year. In fact, we sine-died on Friday at 11 a.m. Yes, unheard of. The prior 2 or 3 years, we actually had to go into overtime into the weekend, right, to get the budget done. So very smooth landing. Budget's obviously good for the county. Not a ton. Preemptions were passed, of course, not as many as we've seen in previous years, and hopefully with the passage of Senator Passidomo's bill on local ordinances, we'll see even fewer in the future. So we can celebrate our victories right now, but I would like to remind you that we start session early next year. We actually start in January, so committee weeks will begin in September. Calendar's not out yet. It's the expectation, though, that that's when we'll start back up. So we don't have a lot of downtime to get geared up and to start getting our priorities for next session in order. So I will pause there and take any questions.
I got Commissioner McDaniel and then Commissioner Saunders on deck.
Well, I lit up, that was from before.
Sold. Okay.
But I do have a question, if I may, and you may be able to answer it. When John was flipping through the Moving Florida Forward initiative, there was only 24 million appropriated for Pine Ridge in 75, and my brain had a memory of 90 million for that divergent diamond.
So that may have been for just this next fiscal year. Oh, John's still behind me.
Actually, that information came directly from the governor's website for the program. So that's what he was planning all along. Now, whether or not that $90 million was a longer range projection, to Lisa's point, that could be the case. But for right now, that's what it is billing it as.
You know what, we'll be able to verify it on Friday, our MPO meeting this Friday. I'll be able to verify that, okay. Thank you. And from me to you, thank you. You have been an enormous boost to our community for what your efforts have provided for our county in Tallahassee. And from me to you, thank you.
Thank you.
Commissioner Saunders.
Thank you. I also want to thank you for all of your efforts. I've spent a lot of time in Tallahassee, and I worked with a lot of lobbyists when I was in the legislature and when I got out of the legislature. And you guys do a wonderful job, and it's noted and it's appreciated. Mr. Mullins, you do a fabulous job as well in coordinating all this, and that's hasn't gone unnoticed and is appreciated. I know you have staff that work with you, and everyone does a really great job. I do have a couple things. There's going to be an OPAGA report coming out in the next couple of weeks, I believe, or maybe sometime in June, dealing with the issue of noise pollution in Florida. Are you familiar with that?
I am.
I'd like to
I'm familiar with the local issues.
Yes,
here.
okay.
Yes.
I'd like to make sure that we get all of that information when it comes out. I don't know if we have any opportunity at this point to be involved in the final report. I assume probably not at this point, but there have been several phone calls, conference calls in reference to that. And so I'm very interested in that. And we may have, in terms of our next legislative agenda, going into 2024, we may have some quiet Florida type of issues. I think that was really the only thing I wanted to bring up in terms of the potential for a future agenda for you. So thank you again for all of this material.
And I'll certainly keep my eyes out for the report, and I'm happy to touch base with them even when I get back up to Tallahassee to kind of see where they are in the process, and to make sure, you know, in any of our positions or information that we can share with them, that we've done so.
That would be great. I appreciate
Sure.
it. Thank you.
Any other questions? Okay, I think we're good to go. Thank you.
Thank you.
All right, I think we're hitting the end here, right? What else
Yes,
you got
sir.
there, County Manager?
Brings us back to item 15, and we had left off at the Commissioner Communications.
Okay, so just,
Oh, if we want to check one last.
We have none.
No public comment. Okay.
Okay.
So we're back to you.
okay, I'm actually going to start off just by, on behalf of all of us here, thanking everybody for this morning. You know, it was great to have a packed house in here, and former officials, former county managers, a lot of business and tourist people. So great event. I can't wait to see all the photos posted, you know, by the county and all of us as well. To Mr. Mullins, thank you yesterday for Everglades City. You know, we were out there. It was a great event. I know you had a whole team of people as well that pulled it off. That was great to be out there in such a historic spot with Baron Collier III. I want that guy to adopt me, right? Right. What's that?
No, he was.
No, he was a third. Yeah, we didn't get. There's a fifth. What is he, 7 or something, or what? How old's that kid? It was kind of funny that he said, "I never met my grandpa. I'm not really responsible for any of this, and I'm a horrible public speaker," right? But he actually really spoke off the cuff, and it was great. But thanks so much. And same to our county manager. You know, I know Ms. Patterson, her team was very involved in making yesterday and especially today, you know, happen. You know, thanks very much for that. Having said that, let me go to my colleagues. I'll start with Commissioner Cowell.
Thank you, Chairman. Yeah, I'd just like to echo that. I really appreciated everything the staff did and what y'all did yesterday down at Everglades City. I was quite impressed. And to partake in something like that and be part of this 100 years of Collier County. And I'll just kind of roll off into what statements. I know we had the curator from our county museums here, and she was walking around the room and talking about our rich history. And one thing that kind of touched on me, she had made the comment, and we're talking like in the early 1940s, that you know, we wouldn't realize that Naples wouldn't have had the attention it had if it wasn't for the actual airport. She touched on it, and you know, I started thinking about it, and you know, the men and women that there was stationed here from the Army Air Corps back in 1940s were from all over the country. You know, they were the eyes and ears that sent back this beautiful paradise back to the other states that they came from. And, you know, by being stationed here in that early time and kind of brought the attention to, and probably made Naples what it is today, you know, because it got spread around. You know, you got young 19, 20-year-olds, never been away from home, and, you know, they're plopped down here next to these white sand beaches and, you know, making $10 a month working for Army Air Corps in 1940. But so I think the airport, we have to look at that too as a very, very important part of our history that made our history here. And I don't know if it is or what, but I know the airport now falls under It was annexed by the city at some point, and I know there's some things going on with the city and the airport, to the point that the city's actually hired an attorney at $1,000 an hour to try to shut the airport down, basically. That's where we're going. So I think it is a part of our history, and I think we probably have a duty in some way to make sure that's preserved. And, you know, that being said, I just wanted to make sure, I wanted to make a statement on that and bring that awareness to our board and everybody else who might be listening out there. And another thing, you guys might already know the answer to this, and maybe I just overlooked it, but I know we passed the affordable housing agenda a few months back, and it was sent up to Tallahassee. Is there some sort of report, or is there something, information that comes back to us when that's filed and authorized? Or, I mean, I'm not sure exactly the process on that.
Get Mr. French up here to answer that. For the 4 affordable housing initiatives that were transmitted to the state, those last 4.
Yes, ma'am. Thank you, Commissioner. Again, for the record, Jamie French. So, Commissioners, those were in transmittal. Those will be coming back to you for adoption. The legislation recently passed would not impact those, because this is certainly not more restrictive. This provides additional allowances for developers to move forward. With regards to the surtax bill, that needs to go to your surtax committee, which is scheduled this upcoming meeting, and then once that has been passed, then we would then start to solicit and bring items forward for board consideration.
Thank you. I have nothing more.
Commissioner Saunders.
Thank you. I've got a couple items. I think we may have all received a letter from Mayor Teresa Heitman concerning the Collier County Citizens Corps. I had no idea what that was. I've read all about it. I still don't really know what it does.
I think she's
but it was
referring
full-
to the Army Corps.
Yeah,
Was she-
that's what we were talking about today.
Okay.
She wants to be one of the 15 or whatever the number, 7, you know.
Yeah, and then I misunderstood, because she did refer to the Collier County Citizens Corps,
She did, which is also a thing.
which is a thing. And so,
Not our thing.
no, this is
Okay.
2006.
That's why we have a thing.
Okay.
So maybe we need to,
We'll get clarification from the mayor on what specifically she's requesting. If it's the Corps, the Army Corps of Engineers Coastal Resilience Study and that group, the committee, or if it's the actual CCC.
we're going to make those appointments in a couple of weeks.
Yes, correct.
But on the Collier County Citizens Corps, maybe it's something we should repeal if it's not something that's active. Just, I'll throw that out there.
Understood.
It's a very interesting thing, but I'm not sure if it's ever met or has been meeting, certainly in the last 10, 12 years. Then another item, I was told that there's some problems at the Santa Barbara Canal in terms of cleaning it up. So just pass that on, that I was told that basically the entire length of the Santa Barbara Canal, but it's near where the bridge repair replacement is going in, and I've been told that it's in real need of attention.
Okay, no problem. We'll talk to Stormwater about that.
Okay, and then we had a productivity committee meeting a few weeks ago, and one of the issues was the implementation of their recommendations concerning our park and recreation operations, signage and things of that nature. And I'd like to get, I think it would be important for the board to get a little bit of a report back at some point as to what those recommendations were and which ones have been able to be implemented and that sort of thing. Signage was a big issue. Friends of the Collier County Parks was a big issue. And then finally, at our second meeting in June, I'm going to be placing on the agenda an issue dealing with Quiet Florida, and that's one of the reasons why I brought up the OPAGA issue just a few minutes ago, dealing with state legislation. That OPAGA report will probably be out by then, and so I'm going to place on the agenda an item to discuss that. The group, the Quiet Florida group, will be asking us to consider being a sponsor of or placing our logo on and/or putting this information on our webpage dealing with what the law is as it relates to people altering their mufflers and doing things that are, quite frankly, illegal. And so that'll be part of the discussion, and staff may need to kind of provide us a little bit of background as to what we can put on our webpage I know we shouldn't put anything on there unless it's approved by the commission, but what that process would be for consideration when that comes up in about a month. And that is it. Thank you.
Just to piggyback, I actually, when I saw that letter from the mayor of Naples, I thought she was referring to the Army Corps, so that's why I was a little ambiguous with my comments here. I didn't want to call her out, but we're talking about it. But that's where I sit here, and this is just my own personal comment. I think if we're trying to have a group of people that are sort of, equal and peers, we nominate a few citizens, and all of a sudden the mayor of Naples has got one of those 7 spots. It's just something to think about. But I guess we'll see the applicants that come in. But you might be right. She might be talking about something that's quite a bit dated. But I think she means the Army group. But it was like, and my off the top of my head, I would say to the mayor, nominate somebody maybe from your staff. But I don't know that it needs to be the mayor. But that's just me. And I know we're not voting right now. So Commissioner McDaniel.
I just want to echo my gratitude and thanks again for the centennial celebration in Everglades City yesterday. Went flawless in my personal opinion, and thank you again to our lobbyist. Thank you. I just can't say thank you enough. The things the things that you have done for our community are off the chart.
Commissioner Hall.
Just echoing the centennials, one thing I thought was really cool in reading the history, when Baron G. Collier gave the land for our county, his whole name is Baron Gift Collier. And I just thought that was neat. That, you name a man and he fulfills his destiny. And so I just appreciate him from that. So if you hear me, Baron, you just know that we give you the love for that. There is a friend of the mayor's that we talked to her at lunch. She will be applying for the Army Corps of Engineers thing. So I don't know that that's what the mayor was it. So her good friend will be applying. So she said, I'll get right on that. And that's all.
Tell me if you think you were thinking this, but during all of this historical conversations about the centennial, every time they talked about Baron Collier way back when, like bought up a bunch of land, tell me if in your mind you weren't thinking, dang, if I wish I would have been back there, right? I would have bought up every single bit I could have, right? I mean, you think he was buying it for pennies on the dollar, and nobody could have imagined, except maybe him, the Mackel brothers and all that, what could have been. But every time I hear those stories, I just think, gosh, how much was that acreage? It could have been, $1 an acre, and people probably thought, that's crazy. Who's going to live here, right?
I think it was pennies per acre.
Was it?
It was in that range.
People always tell me on Marco that lots used to, when they were like $5,000 waterfront, people thought, that is nuts. That's crazy talk. Anyway, I did neglect to say one thing. I spent Saturday from 9 a.m. to 5 p.m. in Tampa attending basically a state-run MPO meeting where they talked about transportation at more of the state level. So I'm going to go through my notes. I'll send out a one-way communication. There were some really good slides in there that I asked for that might be worth just sort of taking a look at, that talk about how things happen at the state level when it comes to transportation type things. There was, and it was attended by county commissioners. There were mayors there. There were city council members. It was a good group. It was at the Marriott at the airport in one of their conference rooms. But I grabbed everything I could slide-wise, and I thought I took good notes. So I'll put something together over the next few days and send it out. And then at our next MPO meeting, maybe I'll give like a little presentation. But it was really great, and it was great to connect with other peers who have a lot of similar challenges across their different areas. But having said that, any follow-ups? We forget anything? Troy, you got somebody on the line that wants to speak?
Actually, no one on Zoom at all today, sir.
Okay. We're adjourned. Thank you.